Citizenship and Immigration to order. Before we begin, I would just clarify in regards to the technical difficulties we had last time on the Monday's meeting. The clerk has invited the witnesses from the last meeting to submit supplementary remarks further to their testimony, and these submissions will be appended to the transcript of Monday's meeting. Additionally, the clerk has sent the blues of Monday meeting to the witnesses and has invited them to propose amendments to their testimony to ensure that the evidence reflects what the witnesses said in testimony. And just a reminder regarding health and safety, a reminder to all the attendees in the room to physically distance yourselves from others for at least 2 meters. Wear a mask unless you are seated and more than 2 meters from anyone else. This is a hybrid meeting. Some members are appearing in person in the parliamentary present and the others are appearing remotely. Reminder to all the members, please speak at a pace slow enough for interpretation to keep up. The clerk will be tracking if in case there are raised hands and keep a speaking list if needed. All questions shall be decided by a recorded vote except for those decided unanimously or on division. The meeting is being webcast and is available on PalView. With this, I welcome all the members and I welcome our witnesses for appearing before the committee today as we study the impact of COVID-19 on the immigration system. Welcome to all the witnesses. Today we have appearing before the committee a representative from YMCA of Northeastern Ontario, Helen Francis, President and Chief Executive Officer. We also have Fabia Mahmoud, representative from Centre Social d'Aide aux Immigrants. Also, we have appearing before us as individuals, Callie Goldthorpe, Senior Associate, Green and Spargle, Elizabeth Long, Barrister and Solicitor, Partner Long, Bengalji LLP, Alastair Clark, Lawyer, Clark Immigration Law, and also Mark Holt, Lawyer, Holt Immigration Law. So welcome everyone. And with this, we will start with our first panel. Sorry, because of the vote, we are starting late. So we started at 4:11 and end the panel at 5:11. All the witnesses will have 5 minutes for their opening remarks. I would invite Mr. Callie Goldthorpe, the Senior Associate from Green and Spiegel, to please start. You have 5 minutes for your opening remarks.
Good afternoon. Thank you for inviting me to discuss these very timely immigration matters today. So certainly in the early days of the pandemic, it was understandable to expect service disruption. Prioritizing critical infrastructure, essential services, and the containment of COVID-19 was rightly made a top priority. But we're now 8 months into the pandemic, and though there may be some light at the end of the tunnel, there's no clear indication that the pandemic is ending anytime soon. And IRCC processing of applications is falling behind. We've all had to learn to live with this virus in different ways, and the Department of Immigration, Refugees, and Citizenship is no different. The department's delays can no longer all be attributed to COVID-19. So in the context of family reunification, estimated processing time is about 12 months. This was the case pre-pandemic, and it's still communicated to be the processing time right now. 1 year is a long time for families to be separated. Now, the recent expansion of exemption COVID-19 travel bans in place presents some inequities too. So namely, the extended family members, such as long-term romantic partners, may be reunited in a matter of weeks, while married spouses and common law partners overseas have to wait upwards of a year. And timely reunification is even becoming more urgent for families adversely affected by changing conditions in countries like Hong Kong and Lebanon. We've all had to adapt and innovate, improve and take advantage of the new tools available for us to be more efficient while working remotely. And IRCC has to be creative and innovative in their processes and flexible in their approach to assessing and processing applications. In Canada, ministerial instructions allows the department to make changes quickly. So as a suggestion, we'd like to see the deferral of biometrics to the back end. When foreign nationals are entering Canada at an airport or land border instead of upfront at the time of the application. Right now, temporary resident applications are delayed at the biometric stage. Applicants in certain parts of the world are waiting weeks to get their biometrics scheduled. Their applications aren't even in queue for processing until the biometrics are completed. So my suggestion is the solution is to defer biometrics to their arrival in Canada. We know that border services officers at CBSA ports of entries are operating at much lower capacity than pre-pandemic levels. In some cases, 5 or 10% of where they were in 2019. The port of entries have the equipment to do biometrics and they have the capacity to do so. So why do we wait? Why do we make applicants do biometrics up front, wait several weeks for an appointment when they can be doing them at the back end? As well, do visa counterfoils have to be affixed to an original passport? For visa required applicants, the passport transmission process can take weeks. In contrast, an electronic travel authorization for visa exempt nationals can be linked to a passport in mere minutes. Eliminating the visa counterfoil can save time and resources. In Canada, there's currently no dedicated temporary resident program that allows overseas spouses and dependent children to be reunited in Canada while their applications are in process. In contrast, an in-Canada sponsorship application can request an open work permit for the sponsored spouse while the application is in process. So this is a great program, but it's limited to those who are currently in Canada or those who are able to obtain a visa and enter Canada before submitting the application. For spouses who are in visa required countries, it's difficult to get authorization to enter Canada because of Section 179B of IRPA, where applicants must demonstrate an intent to leave Canada when their visa expires. This conflicts with the intention of applicants who have sponsorship applications in process who intend to become permanent residents. With respect to the parent and grandparent lottery system, we know there's a persistent high demand for the program in light of limited number of available spots and the challenges of managing the intake. Since the program reopened in 2014, each iteration of the intake process has been frustrating. Currently, success in securing an invitation to apply in the lottery system is contingent on the luck of the draw. The lottery system does not adequately screen for eligible sponsors. It does not require supporting documentation to show that sponsors meet the eligibility requirements. So more people can enter the lottery than are eligible, which then lowers the chances of selection for those who do meet the requirements. Improving the lottery system to ensure that only eligible sponsors could enter the lottery can make the system fair. As well, allowing unsuccessful sponsors from previous years to re-enter with weighted probabilities could increase their likelihood of selection in subsequent years. An alternative to the lottery is maybe potentially for pre-screened eligible sponsors to be put on a wait list for sponsorship, which then could provide predictable timelines and better manage expectations.
Sorry for interrupting, Madame Goldthorpe. Your time is up. Maybe you can touch base on the other points as we go into the round of questioning. We will now move to our next witness, Madame Long, Elizabeth Long, barrister and solicitor from Partner Long Manjil LLP. Madame Long, you have 5 minutes. I will just give a 1 minute's head up. When we are by 4 minutes, I will let everyone know that 1 minute is left. So, Madame Long, you have the floor.
Thank you for inviting me to testify. Let me first speak to the issue of international students. This is an area that is currently filled with chaos and confusion, especially as it pertains to those students who have applied abroad. You know, we often have the IRCC website saying two completely different things. For example, there is a question of whether someone could study online if they had already applied for their study permits but had not obtained an approval in principle. We had the instance where one IRCC was saying yes and the other was saying no. We also don't have clarity on what certain policies really mean. For example, what does an approval in principle actually mean? Will their applications be approved pending medical and criminal checks, or are there going to be other checks that will follow? There are also certain policies that are still being applied with pre-COVID conditions in mind. For example, the ministerial instructions for express entry. It still states that students need to study for 8 months inside Canada and requires that the online component be less than 50% in order to obtain the points for studying in Canada. And we know this is not going to be the case for many students during these times. We need clarity and reasonable outcomes to allow schools and students to properly plan their futures. We're currently in a tight race to attract these international students, and convoluted rules and contradicting information makes our system seem unfair and ultimately unattractive to potential students. Secondly, I like to address the parents and grandparents category. I like to say that this category, first of all, serves not just a humanitarian purpose, but it's also an important economic one. COVID-19 has highlighted the importance of grandparents, that we need them to often take care of children while the parents are at work. And oftentimes, those who are most in need of parents to be here to take care of the children because the family just can't afford childcare are not able to meet the LICO plus 30% financial eligibility line. That's why I think it's important for the sponsor's income to return back to the LICO line so that those who are most in need of parental help can have them here to care for their children. On the other hand, I have also known many instances where parents who are sponsored are just not able to adjust to a life in Canada, and they're actually not willing to live in Canada on a permanent basis. That's why, to address the numbers issue, I would recommend a priority processing for parents and grandparents who have lived in Canada for over 1 year, and we know who are able and willing to reside in Canada on a permanent basis, and have them processed on a priority basis compared to others. Finally, with regard to family reunification and spouses, right now we have such a stark difference between those with family in visa requiring countries and those in non-visa requiring countries. Those in non-visa requiring countries, even if they have someone who have just lived with them for a brief period of time, they can have their boyfriends and girlfriends travel to Canada. They're able to get on the plane right away, or just get a letter of authorization within 14 days. Once they come into the country, they can get their open work permits if they've applied for spousal sponsorships in line, and there's also priority processing for these applications. Now, if you compare that to families who are in visa requiring countries, the situation is completely different.
Madame Long, you have 1 minute left.
Thank you. As my colleague has already said, the temporary resident visas for those who are married to Canadians or permanent residents are routinely denied because they're seen as having too many ties to Canada and are not likely to leave Canada. And even if they're able to obtain their visas, these visas right now are taking 4 to 5 months to process, and they require biometrics from centers which we know are often closed. And for the permanent residents, there's no end in sight for processing. They're not included in the expedited processing. And for most of our applications, we have actually not received a confirmation letter for anyone submitted since March of this year. Furthermore, if the COPRs are not being issued, we don't know when they're going to be coming to Canada. And the realities of the situation are heartbreaking. We have a client, for example, who's in a wheelchair in Canada. He's been trying to sponsor his wife for 19 months.
Madame Long, your time is up. You will have an opportunity as we go into the round of questioning. Next, we have Madame Helen Francis.
Nous avons maintenant Madame Helen Francis qui représente le YMCA du nord de l'Ontario. Merci beaucoup. Vous avez 5 minutes. Merci. À titre d'organisation de bienfaisance, nous mettons l'accent sur la croissance de tous, esprit et corps. Nous mettons l'accent sur les services à l'emploi.
There are some interpretation issues. I'm hearing English and French both. I'm hearing the interpretation while I'm on English.
Me too.
Mr. Clerk, can you please check?
Could you please switch your channel to English and try again?
Madame Francis, can you start?
Absolutely. So good afternoon, and thank you for the invite. The YMCA is a charity that is focused on the growth of all in spirit, mind, and body. And one key area we focus upon is employment services and immigrant and newcomer settlement services. So my comments here today are primarily through the lens of settlement work and workforce development versus direct work within the immigration process. Through our settlement service experience, clients are experiencing long delays, be that for student visas, permanent resident status, or work permits. And as a settlement service provider, we obviously advise clients to be prepared for the delays. However, it can inhibit our ability to provide or connect clients to community services, for example, medical care. As you know, immigrants are not eligible for OHIP without the permanent resident status, and there are limited to no alternate options throughout the community. It is not uncommon for our newcomer clients to travel to Toronto to receive medical care. Securing employment may also be challenging for clients who either experience delays in processing their work permits or those that require changes to their work permits. Delays and lack of direct support available in our region require that clients must travel to Toronto to access key immigration resources, such as legal representation, which is not ideal at the best of times, but certainly adds risk for COVID-19 transmission between regions. In northern and rural Canada, we also know that we are reliant upon immigrants to address the current skills gap that exists across various parts of the country. However, it can be more detrimental to regions such as northeastern Ontario, where the gap is widening at an alarming rate. The current restrictions on immigration or delays within the process may lead to long-term ramifications across the country, particularly in northern and rural regions known as second migration centres. Failure to address the current backlog will limit the rate of new immigrants arriving in Canada when restrictions begin to lift, potentially diminishing the rate of second migration in areas such as northeastern Ontario, the impact of which can hinder not only our country's ability to reopen for business as and when the pandemic allows, but potentially negatively impact our long-term economic prosperity. Our recommendations for areas of improvement for your consideration would be: number one, accelerate processing time for permanent residency and visas, as well as family reunification to ensure individuals, young people and families are safe, secure and connected. Number two, consider the location of immigration lawyers outside of the typical large urban centres. Specifically, we would like to see one in Sudbury. Number three, provide satellite immigration services to serve northern and rural communities. Sudbury is a centralized location to northeastern Ontario and would greatly benefit from key satellite services. Number four, easier access to IRCC to enable service providers to connect clients to immigration consultants. A representative dedicated to regional areas would facilitate access to key immigration services. Number five, universal English as a second language access for all newcomer clients. Current services are exclusive to IRCC eligible clients.
Madam Francis, you have 1 minute left.
Thank you. For example, permanent residents, conventional refugees. And number six, support to provide settlement services for international students. The current funding model does not reflect this demographic, and the provincial funding is insufficient to adequately serve this growing population. And finally, our team is very successful at connecting people on a social level within the settlement circle. However, there is a local gap to address systemic racism. Adequate support for settlement service providers to drive and engage in anti-racism efforts would be helpful, and we acknowledge that the IRCC have launched programs recently to support such initiatives. Thank you for the opportunity to speak today.
Thank you, Madam Francis. Thanks to all the witnesses for your important testimonies. Now we will move to our first round of questioning, and we will start with Mr. Hallen. Mr. Hallen, you have 6 minutes.
Thank you, Madam Chair, and thank you to all the witnesses for coming to the committee today. Family reunification and the impact of COVID-19 has been a very important issue, as we've heard. Earlier this year, the government put the program for parents and grandparents sponsorship on pause. Committed to making a new announcement in spring, but it was further delayed. There's been a lot of criticisms in the past, and even with this new system, we see a lot of people that had a lot of issues with it. Again, like we've heard. Canadians in the past placed their hopes on bringing their loved ones to Canada on a more efficient level. Many were very disappointed with the overrun in minutes that happened with the first program they had. And now with this new system, again, there's a lot of questions around it. There's a saying about what insanity is. It's doing the same thing over and over again and expecting a different result. And in the last 5 years, that's what we've seen. So my questions are for Ms. Long and Ms. Goldthorpe. My first question is I would like to hear your thoughts on how you think the government has handled this program in the past and the impact on the pause that happened earlier this year, and the decision to re-implement a lottery. Please, Ms. Long and Goldthorpe.
Shall I start? Um, in terms of the clients that I have seen, it has become an extremely stressful situation to have your parents, their ability to join you, be the subject of a lottery. This is not something, it's almost like we're playing with people's lives. What we are seeing is, people are really, really suffering with their families not being able to join them. Their parents aren't able to be here to take care of their kids. And it's been devastating in the past 5 years with the very, very small numbers of people who can actually go through the system. It's unfair and it's unjust. And what we are suggesting is that we return back to the first come, first serve situation, and also increase the numbers so that people can actually have some peace of mind that they've submitted their application and they're able to eventually somehow sponsor their parents.
Yeah, so with the delay in launching the lottery or the parent-grandparent system this year, it was only just earlier this month where people were going into the lottery. We haven't seen the results of people who have won basically their golden ticket yet. So we don't know what the process is. There's no transparency. There's no indication of how people are selected, what they do with duplicates, how eligible applicants are selected. And there's just no transparency in that process. And so that's what's frustrating for my clients. And that's what I'm seeing and hearing from my clients in terms of the frustration of the parent and grandparent lottery is that there's just no transparency. And the other thing that we're seeing is that people are going into the lottery not necessarily being qualified as sponsors who may not have the required income levels, or they're going in twice, duplicating their chances. And so because there's no transparency on how the winners are selected, it's really frustrating for the clients and to go through this over and over again. It's frustrating, and the long wait. The suggestion of having the weighted lottery system has been repeated over and over again, and it's an easy fix where if somebody's been in the lottery before and has been unsuccessful, then they get 2 kicks at the can in this lottery, and that's the urgency that I urge the committee to look into.
Thank you very much. I think you both touched on some very important points. Ms. Long, you also mentioned in your opening statement about how important it is for people to have their parents here. And now more than ever during this pandemic, we know how much emotional support people need. I want to again ask you both again, what do you feel, how can we make the system better? What are your suggestions on making this better so we can get people reunified?
So in terms of my suggestions, I think we should stop with this sort of lottery system or first come, first serve and seeing who has the highest internet that you can get in. I think we need to increase the numbers and give people first come, first serve. You submitted your application, and then you have the peace of mind that you're waiting. And we have a sort of system where you know how many people are selected for this year, and you know whether or not you can go through this year or next year, but you're there. Second thing that I'm recommending is a lot of times, some parents, they are sponsored and they're not able to stay. And then there's other parents who just want to stay and they're needed in Canada. And so perhaps we have the best indication of future wise is, past experiences. And so for parents who have been living in Canada for at least a year or two on these super visas, perhaps they can receive priority processing in a separate line compared to other people.
Sorry for interrupting. Time is up. Now we will move on to Mr. Saray. Mr. Saray, you have 6 minutes.
Thank you, Madam Chair. Merci beaucoup à tous les témoins.
Thank you to all witnesses for your testimonies. This will help us with our study on the pandemic. I would like to focus more on employment.
To Helen Francis from the YMCA Northeastern Ontario. And first off, I want to thank you for all the work you do in the area, and when you look at the highlighting the satellite and the remote and the challenges that we have and the importance that we have that we want to bring immigration newcomers to Northern Ontario. So I want to thank you for the services. My question is more linked to when we look at the partnership with the federal government, RC. CC and immigration settlement services. What can you provide some recommendations to us to strengthen that role between yourselves and the federal government to ensure that we could bring in more newcomers? And also the second part to that, can you just expand a bit? You mentioned about the lack of provincial funding for the international students to study. Can you just expand on that part too, please? Merci.
Certainly. So thank you very much, Mr. Seri. The first really circles back to the role of settlement services, and commonly we experience clients that will come to us and indicate that they can't get a hold of anybody at IRCC. And the breakdown in the partnership there is that we too don't have direct contacts or a direct representative to work with at IRCC to really reach out to and understand where the breakdown in communication might be. So we end up really as helpless as the client themselves. So that's unfortunate, and it's possible that if we could strengthen the relationship there with our IRCC colleagues, that it would actually help everyone in this entire system. When it comes to settlement services for international students, certainly for ourselves as an association, the current funding models don't include funds for us to specifically support international students. And happily, we see that that is a growing trend in our educational establishments to attract and recruit those students, but they need a lot of support. And in order for us as a settlement provider to be able to do it, we need those funding models to expand so that we can actually have the resources in place to provide the supports appropriately.
Thank you. And a question for Elizabeth Long. I want to shift a bit. You mentioned about the importance of international students, and we're all going to agree that we need to attract more students. But also, I wanted to hear your recommendations to the federal government. How can we, to meet our immigration targets, attract, and we've done some, and we could do better on that, but more importantly, how can we have the existing students that are here in Canada, some of the recommendations to make sure that we fast track them on the PR side for permanent residency? What are your recommendations along those lines, please?
Absolutely. So right now, international students, in order to attract them, it's all about permanent residence. It's all about that path towards permanent residence. And, we are doing well in some certain ways compared to other countries, but we could certainly do better. So first of all, right now, a lot of the rules surrounding students with regard to them coming into Canada, their ability to qualify for the post-grad work permits, their ability to qualify under express entry is up in the air, and it's very, very confusing to students. And whenever something is not clear, that has a hesitation for students to actually apply. The second thing is with regard to permanent residence. Right now, we are putting students who have studied in Canada, who have worked in Canada, in the same pool as everybody else from around the world. For us, we should recognize that international students who have studied in Canada, who have worked in Canada, are our key candidates for permanent residence, and we should really have a special category to allow them to immigrate instead of just putting them through express entry.
Thank you for those recommendations. Ms. Helen Francis, I just want to hear a bit more about what can we do as a federal government to support settlement agencies like yourself to ensure that we provide better supports, especially for newcomers, for reintegration in the workforce. So along those lines of more utilizing technology, innovative ways, what can we do to leverage some of that technology to increase employment supports?
Well, certainly for us in Northeastern Ontario, we do have a little bit of a digital divide in terms of internet accessibility. And certainly, I think that we've certainly seen within COVID that our vulnerable populations, including newcomers, feel that more acutely. So yes, there's room for us to improve access to those types of tools, particularly when we're relying very heavily on the virtual communication through COVID. But that's true even outside of the pandemic. It's great to have tools that are online, but if folks do not have access to it, we need to make sure that it's more readily available. The other components, I think, in terms of the workforce that we need to understand is that in Northeastern Ontario, we're heavily reliant.
Francis, sorry for interrupting. Time is up.
Okay.
We will have to move to our next member. Madame Normandin, you have 6 minutes. Please start.
Merci beaucoup, Madame la Présidente. Merci à nos...
Thank you, Madam Chair. A lot of information. You are providing a lot of information that will be useful for our recommendations. I would like to go back to Mr. Goldthorpe. With regard to biometrics, there have been a lot of talks about using biometrics in Canada. A lot of people are coming from countries where they do not have access to biometrics.
Can you remind us what biometrics is? What is it used for? And why is it not problematic for it to be done here in Canada at the end of the process?
So biometrics is a requirement. It's a new requirement as of a couple of years ago. So it was not always a requirement for the immigration or the temporary resident process. So biometrics is a photograph and fingerprints of everybody that is entering Canada, with the exception of American citizens from the United States. And biometrics is a part of the process for permanent residents, as well as for work permit, study permit, and visa applications. Now, at the start of the application process, applicants submit their application online, then they get an invitation to do biometrics, where they take that requisition letter, they go to a center to do their biometrics, they take their photograph, and then they do their fingerprints. And that's automatically linked to their application for a 10-year period. So applicants only have to do biometrics once every 10 years. And it's a way to verify identity. And it's possible to do biometrics at the airport, because for visa exempt citizens, like people that are coming from Europe and Australia, for example, those who used to get their work permits issued upon arrival in Canada at the port of entry would do their fingerprints and take their photograph upon their arrival in Canada. They pay the $85 biometrics fee. Then the border services officer, takes their photograph and their fingerprints, and then that's linked to their application and their profile for 10 years. And so it's an important tool for IRCC to establish identity, and it's information that's shared between Canada and several other countries. And so it's information sharing, it's information gathering. But it doesn't need to be done at the beginning of the application process, because it can be done. There's equipment, there's personnel, and there's capacity to do it at the end of the process as well. And right now with COVID, doing it at the beginning of the process is delaying the application for everybody.
Merci beaucoup. J'imagine.
Thank you. I think Ms. Long would have had the same answer, but it would be very worthwhile to include this information in our report. I have another question for Ms. Goldthorpe and Ms. Long. For people coming to renew their work permit at the border, there are now wait times up to 180 days that are not always recognized by their employer. Is there something that can be done quickly so that the work permits can be renewed quickly so that people don't run into problems? Especially, I think of the case of guardian angels. They had not accumulated the necessary number of hours. Thank you.
Yeah, so the work permit extension applications are currently taking upwards of 6 months, which is a really, really long time. And it's not just for people that need to extend their stay, it's for people that are changing the conditions of their work permit. So if they're moving from one employer to another. Now, there's been some, innovative programs that have allowed for the quick change of employers, but the work permit application extension is taking about 6 months right now, which is causing hardship in terms of getting housing, in terms of getting extended health care, and also with respect to social insurance numbers. So there are immigration impacts on other aspects of people's lives while they're waiting for their work permits to be extended. They can't travel, otherwise they will lose their implied status. And if they leave Canada before the work permit is issued and they try to come back, they don't have the right to work. And so the 183 days, 6-month processing times is very, very problematic for people that are basically stuck in Canada until their work permit can be processed. And it's a matter of just printing out a work permit or maybe issuing a letter that authorizes employment. And there's been some new letters from the government that talk about implied status and say that the candidates are allowed to remain and have access and remain in Canada. And but there's a date on that letter, which is problematic. It's a arbitrarily decided date, 4 months from the date of the application, whereas implied status based on 186U of the regs has no date. So if a person is receives that letter, the employer
Sorry for interrupting. The time is up. We will have to move to our next member. Ms. Kwan, you have 6 minutes for your round of questioning. Ms. Kwan.
Thank you very much, Madam Chair, and thank you to the witnesses. I'd like to just first touch on the issue around Section 179B. And for the folks who are trying to bring their loved ones here to come for a visit and who are often denied, the government, of course, cites dual intent, and we know that even with dual intent, in fact, with dual intent, often the applications are rejected. So given that this is a situation, so to Ms. Goldthorpe and to Ms. Long, would you recommend for the government to suspend the use of 179B, especially during this COVID period? And then extending to that, really, for those who have a sponsorship application in place for their loved ones, why not provide a special temporary visa, if you will, so that people can come to Canada, sort of like the parents, grandparents super visa, and so that they can reunite with their loved ones while they wait for their application to be processed. Just like to get your thoughts on that.
Yes,
so go ahead.
Yes, I absolutely concur that it is the inequities between someone who is from a visa requiring country and someone who is not is very, very stark. And especially during these times when processing times are just through the roof, it's very important to have a way for family members to come to Canada. And, the dual intent is often applied in such draconian ways at visa posts where they instead of applying dual intent where they say, well, someone follow the laws, they're applying does someone have permanent intent? And if someone has permanent intent, it's almost as if there is no dual intent involved. And I think if we have a policy where it is stated that these are the things that someone has to show. They have to show that they have family members in Canada. They have to show that they have never disobeyed the laws in Canada before. That's enough. That is, we have to have a clear line as to what is enough for someone to obtain a visa. It should be the same criteria as someone who has an ETA. An ETA is issued in a matter of seconds. Why is it that someone who is from that country can get an ETA, they can come right away, where someone from a visa requiring country is requiring perhaps never to be able to get that visa to come to Canada?
Thank you. Ms. Goldthorpe?
Yes, the 179B is highly problematic. The dual intent purposes, basically, if there's a sponsorship application, that's viewed negatively, and it's a factor that's viewed towards refusing a TRV application. And requiring spousal sponsorship applicants to additionally apply for a TRV just adds another layer of expense and processing for them while they're being processed for their spousal sponsorship. So it just adds another layer of expenses for government processing. It's just an additional application that wastes government resources, knowing that the applicant is going to be staying in Canada permanently once their permanent residence application is completed. So I completely agree with the fact that 179B is very problematic, showing dual intent is very problematic for visa required individuals that are being sponsored to Canada.
So should the government suspend the use of 179B?
I mean, I think so, because they're allowing boyfriends and girlfriends in a matter of weeks with just a statutory declaration of being in a long-term relationship, and there's no issue of looking into how long those people are going to be staying in Canada. And so the inequity is very, very stark between that and those who are married and who have a stronger, a more solidified relationship.
Thank you. I'd like to just turn my attention to the certificate of PR. We know that people are held up because their certificate of PR has expired, and then they have to wait. And in fact, IRCC right now, even as it stands, and I've got a boatload of cases where people have no idea when they can get their certificate of PR renewed. And that's the only thing that's barring them from getting into Canada, and they've gone through the entire process. So do you think that the solution for the government to proceed and to move forward on this is to honor the expired certificate of PR? Ms. Goldthorpe, and then I'll go to Ms. Long.
Yeah, absolutely. The COPR is, if it's expired, it's expired because of COVID. Now it's not through the applicant's fault, due to nothing that the applicant has done. Now the COPR, if it's expired, some of them are being requested to redo a security clearance or redo their medical check, which means they have to go back out into the community, go to the police department to do their security check or go do a medical, wait for the results, and then wait for a new COPR to be issued. Again, it's a waste of resources. And so, the easy fix is to just automatically add a 12-month period to the COPR date by ministerial instruction or public policy instruction or whatever, and have these people be allowed to come. It doesn't make any sense to require an applicant to redo a medical or a police clearance. They've just done one in the past 12 months.
Sorry for interrupting. The time is up. We will now move to our second round of questioning. Based on the time left for the first panel, we will have 4 minutes for Mr. Allison and Ms. Dillon, and then 2 minutes each for Ms. Normandine and Ms. Kwan. So, Mr. Allison, you have 4 minutes.
I'm going to start with Mr. Raquel is going to start with my time.
Okay. Thank you.
Thank you, MP Allison, and thank you, Madam Chair. I have a quick question, or it's not a quick question, it's fairly complex, I believe, but for Ms. Goldthorpe and Ms. Long, I think you've given a lot of testimony today. Thank you very much for your expertise in regard to family reunification. But I'm wondering if you can just summarize for the committee, do you believe that family reunification has become more difficult in the last 8 months since the pandemic?
In terms of permanent residence and in terms of being actually to be able to be together, absolutely. The waiting, it's not necessarily the criteria has become more difficult, but in terms of practicality, in terms of waiting times, absolutely.
Thank you. Ms. Goldthorpe?
Yes, I completely agree in terms of permanent family reunification as well as temporary family reunification for people that are wanting to join their Canadian citizen spouses from other countries or travel with their Canadian citizen spouses from other countries. In the early days of the pandemic, those Canadian citizen spouses were not able to have their foreign national family members come into Canada. It wasn't until a federal court lawsuit happened where people were finally allowed to come in, and the orders and councils were changed for family reunification. During COVID, our clients are seeing barriers every step of the way in terms of being able to join their families, come up, be not only reunited, but to be together with families traveling as a family unit.
Thank you both for those answers, and I certainly agree with you. Everyone on this committee has heard heartbreaking stories about family reunification, just so many people falling through the cracks, processes taking very long, much longer than they say on the website. I just mentioned that because 2 days ago in the Canada-China Committee, the Minister of Immigration had said that under his leadership and under his government that family reunification has never been easier. So I just want to get your expert opinion on that, and I appreciate that. And Madam Chair, I'll provide the remaining time will go to MP Allison. Thank you.
Thanks. Thanks very much. So I got a quick question for you guys. I talk to businesses all the time, and they say the process is very complicated in terms of, the federal with the provincial municipalities and needs like that. They're calling on a bit of a strategy, and I just want to get your thoughts on what you would think about that in terms of trying to figure out when people are looking for work, meaningful work, and they're trying to figure that out. Would that be helpful to have some type of national strategy that's sort of played in? I mean, that's also part of the issue, I believe, when we start looking at bringing people to remote parts of of Canada, being able to get to and help companies where they're at. Any thoughts? Does anyone want to tackle that at all?
I can just jump in from our experience in employment services and workforce development, and certainly it is very hard. It makes it harder for us to encourage employers to take on newcomers and immigrants when they know that they might run into process delays, particularly when they've got a work permit, and if they have experienced then the need to modify or extend, and it taking so long, it's a deterrent for a number of employers to take on what would be ordinarily a great opportunity.
Absolutely. Absolutely. With regard to, we have, there are two groups of people that I see are suffering quite a lot. One is the students. During these COVID times, oftentimes they are in trouble in finding work. And in order for them to stay in Canada, they have to have that 1 year of high skilled work experience in Canada or a job offer. And that's really difficult, even though they are willing to work.
Sorry for interrupting. The time is up. We will have to move to Ms. Dillon. Ms. Dillon, you will have 4 minutes.
Afternoon to all our witnesses. Thank you for being here today. I'm going to put my comments and question to all the witnesses so anyone can answer. It's regarding work permits. In May, our government introduced a new measure to drastically reduce the time it takes for a temporary foreign worker to start a new job. While this policy is here, a worker already in Canada who has secured a new job offer can begin working in their new job even while the work permit is being processed. This cuts processing delays from 10 weeks to 10 days. Do you feel this is an appropriate solution to work permit delays? Thank you.
I can give a live experience on that. So we recently had somebody apply who had an open work permit, and we applied for a new work permit for that person. But that person can't switch to the new work permit because their previous work permit was an open work permit. And so the closed employer work permit, they're still going to have to wait. So it only helps the people that meet the narrow criteria for that public policy change. And so while it is very helpful and we've been successful in getting the work permits changed to new employers, and employers do appreciate the ability to have workers come in quickly, what I've been seeing is for foreign work permit applications, I just looked at the processing times for the UAE, and it's 51 weeks. And a business is not going to wait 51 weeks to get a worker in from a foreign country. And 51 weeks is going to be, it's not necessarily the correct or the accurate processing time, but it's a deterrent for employers if they see processing times that long.
Furthermore, that process that you've just spoken to, it doesn't also apply to someone who's applying for a work permit in the first instance. So right now, it is allowed for someone to apply for a work permit inside Canada if they are in Canada. And we have many people who are inside Canada who have job offers, but however, aren't able to start their work because they're waiting 180 days through that process.
Okay, well, my next question is also for all the witnesses. Our government, and this kind of links up to my previous question, our government is looking for innovative approaches to helping newcomers and better supporting the integration process. Do you find that increasing employment support and leveraging new technology is the right path forward? And how do you see your organization benefiting from changes at the Immigration Department? Thank you.
There is one aspect of the entrepreneurs that I feel could be better supported in Canada in terms of the policies for immigration policies. The policies right now, there are only very, very few policies, and a lot of them are discouraging people from starting work in Canada. For example, self-employment work is not counted towards work experience in Canada. And so I certainly hope that there is more support in terms of support for entrepreneurs and small businesses to have people be able to immigrate if they are starting their businesses in Canada.
Thank you. So the next question, our government made some changes to the IRCC spousal application system. One of them was to make sure we can first digitize applications and also convert them from paper to digital form. This is a piece.
Ms. Dillon, your time is up.
Oh.
Sorry. We will now move on to Madame Normandine. Madame Normandine, you have 2 minutes.
Merci beaucoup. Je poserai une petite...
Thank you so much. I have one question. Mrs. Gothorpe along can answer that question about parents and grandparents reunification in another life. As a lawyer, I had to fill a sponsorship request for a grandparent. While looking at the file, I knew at the outset that they were not financially eligible, and in a ways they were taking the place of other people who could have been eligible but were not chosen through the lottery. Could we not pre-select these files so we could maintain the financial eligibility? What do you think?
A sponsor, before they can be eligible to go into the lottery, should be pre-screened, and the solution is it's a matter of linking their tax information. And so on a citizenship application, you can link their tax information through the use of a CIN number and permission to link. And you don't need to require or request the submission of the notice of assessment. And so for sponsors that have filed 3 years of income tax, you can get their tax information quite easily and make the determination on based on the income tax documents that they meet their eligibility requirements for the LICO. So that's I think that's an easy, quick fix that the department can look into.
I actually disagree a little bit because in our system, we do allow someone to move forward even if they don't meet all of the eligibility requirements. They can go and ask for humanitarian compassionate grounds and also go to the IAD. And so therefore, if we screen out everybody who does not meet everything on the eligibility in the first instance, we are not going to allow that to happen in the system.
Thank you. The time is up. We will now move to our last member. Ms. Kwan, you have 2 minutes.
Thank you. Thank you, Madam Chair. I'd like to just go back to Ms. Long on the COPR question and about whether or not the government should just automatically renew the COPR and honor it. Just a quick answer on that,
yes.
and I'd like to go to a different question.
Absolutely. People were already eligible before, and they should be already eligible to be in Canada. I don't see any reason for us to spend any more resources in trying to get them to be re-qualified for this at all.
Thank you. That would also save government resources, IRCC resources, to help process the backlog as well. Okay, I'm just going to turn very quickly to post-grad international students. As we know, they have a time-restricted post-grad work permit, wherein they are required to complete 12 to 14 months of high-skill, high-wage jobs. But because they have been impacted by COVID, so their qualification for PR is now impeded. Some of their work permits is about to expire, and people are very anxious. So I just wonder, Ms. Long, whether or not you have any thoughts about what should the government do? Should they just automatically renew these individuals' work permits, because these are talents that are already here in Canada?
Absolutely. It would be such a waste of our opportunities and talent to have these students have to leave Canada because they weren't able to meet their 1 year of work experience in Canada and have time to go through the system. I would certainly recommend that we extend their post-grad work permits. Currently, they only get one in their entire lifetime, but it's a very, very easy fix for them to allow them to extend their post-grad work permits. And then also long-term wise, I would suggest that the government think of a new permanent residency application for these students, similar to what they have proposed for Hong Kong students.
Ms. Goldthorpe, quick answer on this before I run out of time.
Yeah, absolutely. So post-grad work permits, they only get one kick at the can. And a lot of, if they have a 1 year work permit, they're not necessarily working for 12 months in order to meet the requirements for express entry. And so they need to renew or extend a work permit, and they'd have to do it through a labor market impact assessment, where they're basically applying for their job. They're the same job.
Sorry for interrupting. The time is up. With this, I want to take a moment to thank all the witnesses for appearing before the committee and for this important discussion we had. I will suspend the meeting for 2 minutes so that we can allow the interpreters to do the sound check for the second panel. So thank you once again to all the witnesses. If you want to send in some written submissions, you can do that through the clerk of the committee, and we can consider them as we consider the report. So with that, I will suspend the meeting for 2 minutes, and I will ask Mr. Clerk to please do the sound checks for the second panel. Thank you. the second panel. I would welcome Alistair Clark, Mark Holt, and Fadia Mahmood. All the witnesses will have 5 minutes for their opening remarks. We will start with Mr. Clark. Mr. Clark, you have 5 minutes for your opening remarks. The floor is yours.
Thank you very much. Honorable committee members, I'd like to thank you for this invitation to provide testimony on the impact of COVID-19 on the immigration system. I would like to acknowledge that I'm giving this testimony on Treaty 1 territory, the homeland of the Métis Nation, and the ancestral lands of Indigenous peoples. I'm appearing before you today as an immigration and refugee lawyer with more than 12 years of experience. I started my career at an immigration law boutique on Bay Street in Toronto. From there, I practiced at a legal aid clinic assisting low-income residents. And for the past 7 years, I've practiced exclusively immigration and refugee law here in Winnipeg, Manitoba, the heart of the continent. Today, I'll be making 5 brief points. My first point is that IRCC needs to further digitize the system and expand online services. For example, spousal sponsorships and temporary resident permit applications could be easily submitted online. In 2018, the Refugee Protection Division of the IRB introduced the ePost system, and it has been very successful. ePost makes it easy for council to see details of documents that have been uploaded. IRCC has started to use ePost for refugee claimants inside Canada, and this tool may be useful in other contexts. In short, a robust online system may provide solutions to dealing with long processing times and the current backlogs. For my second point, I strongly support the possibility of an applicant posting monetary bonds for TRV applications in the context of a spousal sponsorship application. These applicants are sufficiently motivated to become permanent residents through the family class that there would be low risk in the possibility of them overstaying their visa. I do have reservations, however, if a monetary bond were to become a requirement of all TRV applications. I would not want the TRV application to become out of reach for low-income applicants. My third point relates to applicants in provincial nominee programs. Many of these individuals are able to apply for permanent resident status based on their education and work in Canada. Once these workers receive their nomination certificate, they can apply for a bridging work permit, but that is restricted to their employer. This pandemic has resulted in many layoffs, and it has caused severe hardship. In my view, these work permits should be less restricted and could avoid many issues, including potential problems with flagpoling. For example, a NOC-B worker could be allowed to accept a different NOC-B position without having to obtain a new work permit. Similarly, I also urge more flexibility with post-graduation work permits. They should not be limited to one post-graduation work permit per lifetime. My fourth point relates to refugee claimants. As you know, travel restrictions have essentially closed the border to claimants from the United States. Justice McDonald, the Federal Court of Canada, recently held the Safe Third Country Agreement to be unconstitutional, and it's disheartening this government has appealed that decision. Notwithstanding,
Malgré les conditions difficiles, le Canada a toute une tradition humanitaire et
approach. Part of the reason why I was interested in this area of law is that it is generally non-confrontational. To deal with minor issues, I can easily call a CMO at the IRB, a superintendent at the POE, an inland enforcement officer, or a lawyer at the DOJ. Dealing with IRCC, in contrast, is a constant struggle. When an IRCC officer makes a clear mistake, there's no easy mechanism to get it fixed. In my view, the request for reconsideration system is broken, and MPs are far too often put in the difficult position to act as intermediaries. Bad decisions by visa officers are often easy to appeal to federal court, as I have experienced doing recently, but judicial reviews expend a huge amount of time and resources for both the applicants and the government. The dual intent guidance issued last month is a step in the right direction. However, it does not go far enough to emphasize flexible decision making. An immigration ombudsperson may be a possible solution. In my view, there may also be a tech solution to facilitate better communication with visa officers to address minor issues. In short, I would urge IRCC to adopt a more collaborative approach. I believe there is great merit in continued consultation with stakeholders. Thank you for the opportunity to share my thoughts, and I welcome any questions.
Thank you, Mr. Clark. We will now move on to Mr. Holt. Mr. Holt, you have 5 minutes for your opening remarks. The floor is yours.
Honorable members, thank you for inviting me to speak to you today to share my thoughts on the impact of COVID-19 on Canada's immigration systems. I'm currently serving as the national chair of the CBA, but while I'm here, I've been invited to speak in my personal capacity, so basically not the chair. So any comments that I make are mine alone. I'm grateful for the opportunity to share them with you. The pandemic has caused significant disruption within the delivery of immigration services, but it has also shined a light on areas that desperately need improving. One of those areas is the need to modernize the entire immigration processing network. The complete digitization of the immigration system must be paramount. IRCC has made great strides with temporary residence and express entry. However, all paper-based applications must be transitioned online as soon as possible. Some of the hardest hit cohorts over the course of this pandemic have been those in paper-based queues. This committee has heard considerable testimony regarding the hardship faced by families, spouses and partners, parents and grandparents, and even the most vulnerable cohort of all, the children. We've heard the stories of families trapped abroad with their internationally adopted children, unable to come to Canada because of visa closures. This pandemic and the necessity of social distancing is not going away anytime soon. Because of the over-reliance on overseas missions and their antiquated methods of processing visa applications, countless people have suffered. We must find a way to modernize the issuance of visas. I know security concerns are paramount. However, why must a PR visa be imprinted in a passport in the first place? Why can't a letter with a scannable barcode not suffice? Why can't biometrics be completed at the port of entry when landing? We place far too much emphasis on overseas missions to administer the immigration programs in relative isolation. We need all PR applications to be fully digitized so that they can be processed anywhere within the network, exactly what's been happening with express entry and the temporary resident applications for years. I commend this committee for their desire to make things better for those suffering. Although there have been many proposals put forward, I want to share with you my top 3 list of major concerns that I think should be addressed first. These are areas that need immediate attention. After all, that's the purpose of this committee in the first place, to identify immediate needs and find solutions. The systematic problems that, well, they'll have to get addressed when they get addressed. But my recommendation is not before these top 3. 1, obviously family reunification. I echo what my colleagues have said. The application of Section 179B should be exempt from any family member seeking to be reunited with immediate family. And Section 3D of the Act itself specifically states that one of the objectives of IRPA is to see that families are reunited in Canada. Spouses' TRV applications need to be facilitated, not as we've heard in previous meetings, that they're treated as a kiss of death in many cases. Families trapped abroad with internationally adopted children should never be turned away by this country when a facilitation TRV or TRP is sought. Solution, create another super visa program for those spouses, or create clear, unequivocal program delivery instructions confirming that Section 179B just doesn't apply, and instead an emphasis that Section 22.2, the dual intent provisions, be applied generously by the officers. The second is the PR applicants trapped outside with expired COPRs. They've quit jobs, pulled kids out of school, liquidated assets, and waited on travel letters that never came. This cohort must be landed in 2020. There's no excuse for this not happening. If they can travel, they should be facilitated. So just issue the travel letters to those that are ready and able, apply the necessary resources that are going to need it to get this group through. You know, they're a relatively small cohort, but no less worthy of facilitation. And 3, the plight of our foreign workers on the front lines. There's got to be a pathway to PR for this extremely vulnerable population. They've been exploited long enough, and a program must be created that targets them. You know, the provinces could step up, but this is really a federal responsibility. The Express Entry program could be adjusted to allow increased points for frontline work experience. However, because of the fixation that IRCC has with skilled work experience to the exclusion of low-skill work, a new program would need to be created. This program could be similar to the Guardian Angel program. We could call it the Canadian Frontline Experience Class, the CFEC. We must look first to those already in Canada to reach the ambitious goals announced in the recent Levels Plan. Thank you very much. I look forward to answering any questions you may have.
Thank you, Mr. Hall. We will now move on to our third witness for this panel, Fadia Mahmoud. Madam Mahmoud, you have 5 minutes for your opening remarks.
Thank you so much for giving Centre Social d'aide aux immigrants, CCI, the opportunity to participate in the study being prepared by the House of Commons Standing Committee on Citizenship and Immigration concerning the impact of COVID-19 on the immigration system. I'm going to begin with the family reunification, international students, and asylum seekers. First point is the application backlogs and processing times for, excuse me, okay, processing times for different streams of family reunification and the barriers preventing the timely reunification of loved ones, such as denials of temporary resident visas because of Section 179B of the Immigration and Refugee Protection regulations and the ongoing closures of visa application centers. As a representative of a community center, I prefer to go directly to give an example. Our client, who is a Canadian citizen, Madame Karima Ibrahim, got married in 2012 to a Palestinian husband in Cairo, and she thought that she can bring him to live with her, but up till now, he was unable to obtain even a TRV. Madame Karima submitted a spousal sponsorship application in 2012, and it was refused in the embassy in Cairo in 2012. She appealed the decision. The appeal was refused.
Sorry for interrupting. I'll just, I think we are having some echo in the translation. Mr. Clerk, is it possible to check, or we?
Interpretation advises that the quality of the audio is very low. I'll speak with an IT ambassador and see if we have a solution to suggest. One moment, please.
Is it possible if she can turn her video off, then would it be better?
Yes, we can attempt this, of course.
Madam Mahmoud, can you try? If you turning your video off, maybe the sound quality would be better.
Okay, sure.
Can you say a few sentences so that we can check if this interpretation is getting that?
Yes, sure. So I just would like to continue the situation of my client.
Are we good now? Better?
No, the sound quality has not improved, regrettably.
Okay,
okay.
Perhaps I would ask Ms. Mahmoud if you could please speak just as clearly and perhaps a bit more forcefully into the microphone, just to increase the volume.
Is it better now?
Okay, we can start. Yeah, please resume.
Okay. So I was just talking about Madame Karima, who was refused in the embassy in Cairo in 2012. She appealed the decision. The appeal was refused in 2014 because of inadmissibility. She couldn't submit a new application for 2 years. And in 2017, her husband applied for a TRV. His request was refused under the Section 179B, and he reapplied in 2019. He was refused for the same reason. In 2020, he applied for TRV under the exceptions issued by the Canadian government concerning immediate family members. And Madame Karima also applied for spousal sponsorship. And the last message from the embassy that there are long delays in processing time. It's important to mention that the humanitarian and emotional situation of the family, just to say that Madame Karima doesn't have family members in Canada. Her husband lives on the Canadian timing. He spends hours with her on the phone every day. They are trying to live as a family, spending time together, sharing projects, sharing emotions and their fears of COVID-19 and isolation. For 4 months, Madame Karima didn't go outside her house, and the only one who broke her isolation is her husband, overseas on the phone. Also, it's important just to mention that she lost her mother in the COVID period, and again, she was alone just with the faraway husband. Uh, yeah, also just would like to mention a very personal question. I asked her, are you able to continue like that? She said, I will never give him up because I love him. Madam Chair and the committee, whatever the fears and uncertainty of immigration officers are, I think 10 years of daily suffering is enough to convince the immigration that the will of a Canadian citizen to live with her husband is more important now. It's more important to this lady after she lost also the opportunity to be a mother while waiting for her husband to join her in her country. If you like to have more details about the situation of Madame Karima, she is, and me also, are ready to provide everything. We recommend that special committees deal with such cases, not just to be dealt with as normal cases. Also, another important point in your study is the international students. I will summarize the problem we deal with.
Sorry for interrupting, Madam Mahmoud. Your time is up. If there is anything you would like to provide to the committee, you can also send a written submission. So with this, we will have to move to our round of questioning. And we will start with Ms. Dencho. Ms. Dencho, you have 6 minutes. The floor is yours, please.
Thank you, Madam Chair. I have a few questions for Mr. Holt. And I hope I'm pronouncing your last name correctly, Mr. Holt. Okay.
Holthy, yes.
Holthy. Okay, perfect. Thank you. Mr. Holthy, my understanding is that your law firm represents Derek and Emily Muth. Is that correct?
Yeah.
Yeah. Okay.
On a pro bono basis.
Okay, I just have a few questions about their case. I'm hoping you can provide some clarity to the committee on their experiences and just for the committee background, and I'll allow you to go into further detail. But Derek and Emily have been in the process for the last number of years of adopting baby Zoe from Nigeria, who has significant health challenges and has faced life-threatening illness. And they have really had her, they've been stranded in Barbados, my understanding, for almost a year, trying to get citizenship to get her into the country. And they've had really a nightmare of an experience dealing with IRCC. Can you lead us through that experience and what it's been like from your point of view for them?
Yeah, the few minutes that I have will not do it justice. The reality is they had a lot of problems with getting the adoption through, and they had accomplished everything they needed to do with the government in Nigeria. And because of Zoe's health conditions and the lack of proper medical facilities there in Nigeria, they had to move out of the country before everything was finalized. They tried to get their applications through like a couple other couples had, but for whatever reason, and I think we've got a pretty good idea now, it was kind of put on the back shelf. And so they were stuck for, the part one of the adoption was completed on October the 28th, 2019, their part. And then after that, there was nothing from IRCC. And so they have been doing everything that they can to try to come. They ended up having to go to Barbados because it was the only country that would take both a Nigerian citizen and Canadian citizen and have adequate health care. Well, I should say hospital availability of medical care, because Zoe suffers from sickle cell anemia. And even when they were in Nigeria, she just about died if it wasn't for the fact that Emily was a nurse. And that led them as well to why they wanted to select a child with medical concerns. But Derek just happened to have the right blood type. She had an infection and went septic. He was able to be there to give her blood. And then they both ended up with malaria in the process. And so that led them to realize they needed to leave. Everything was completed with the Nigerian government, so it wasn't a problem. So they went to Barbados, and they've been stuck there since December of 2019, trying to access every avenue possible. Finally, 2 days ago, their grant of citizenship, this isn't a sponsorship, This is a grant of citizenship, was approved, and there really should have been no reason for IRCC to delay this, other than allegations of maybe that it happened too quick.
So when did IRCC first learn of Zoe's urgent medical needs?
All of that was laid out right from the beginning, so there was no mystery about it. Right from the beginning, the family was selected on the basis that they were going to be seeking to be placed with a child that had serious medical conditions, and so it was never a mystery to anyone in the process. And that's what's so heart-wrenching about it is, the best interests of Zoe as a child were not anywhere on the radar throughout the processing of this.
My understanding is the Moose family was in Barbados. Well, it would have been a year now of coming up to December, and they went about at least 7 months without a single correspondence being returned to them from IRCC, and they got so desperate that they had to really essentially expose their private life to the media to get some attention on their case, and they were running down the clock on when they would be kicked out of Barbados, and essentially, from my understanding, having to perhaps leave their adopted daughter there without her citizenship. So did you see a change in the government's response when this went public?
Okay, that's a question I think anybody could answer. To a large extent, our federal policy when it comes to immigration is driven by public shaming. And no one's to be blamed for this specifically, no particular party. This is just the reality of the situation. And in their case, absolutely, like every other situation we've had, when you try to exhaust every single avenue, and understand they tried for almost 10 months to go through the proper channels, reaching out repeatedly to the visa office, all those things. But in the end, it was finally going to CBC, on September the 23rd, and they approached the minister, they approached everyone, and for a variety of reasons, both within the control of the department and outside of the control of the department, they weren't able to get any forward movement, and there were serious medical concerns for Zoe. So September CBC article, and then that's what kickstarted, the global affairs, just keeping them updated, the GoFundMe campaign, the petitions. I just looked today, there was over 38,000 in there.
What do you think needs to change in IRCC to ensure Canadians and others trying to become Canadians are treated with more compassion, dignity, and respect?
Yeah. I worked on the border as an officer. So there's this built into the system, this desire for efficiency. And it's really hard to have both efficiency, fast processing, and an actual genuine caring for people. It's really hard. It costs more money to care. And like I said, this problem has existed through all government transitions. So it's embedded it's systemic within IRCC. I've seen a lot of really, really good things that have happened. I've seen, with the Canadian Bar Association, I've had lots of opportunities to connect with immigration, and they've been really, really doing, what they can to try to make things better. But in this case, you can't control every officer, and how it was dealt with at that level was horrible. It was
Sorry
awful.
for interrupting, Mr. Halsey. Time is up. Thank you, Ms. Dancho.
Thank you, Mr. Halsey. Thank you, Madam Chair.
Thank you. We will now move on to Ms. Martinez-Ferrada. Ms. Martinez-Ferrada, you have 6 minutes. Please start.
Merci, Madame la Présidente.
Thank you, Madam Chair. Can you hear me? I'm having internet and tablet problems. Perfect. So thank you to the witnesses with us this evening. Thank you for being here. I'd like to make a quick comment first regarding what was said during our last meeting. Minister Mendicino was right. The government record shows that family reunification is a priority. Our government has been increasing family reunification every year since we've been forming the government. In 2019, in fact, we had the highest number of family reunification. Over 91,000 in the family reunification category. Here's my question, having made that comment. And I would like to ask the question to the lawyers. Since the beginning of the pandemic, you saw that certain measures were taken by the department to adapt to the trying pandemic situation. whether it be new policies put in place or innovations, among others. Could you please speak to us more on what, in your opinion, are the policies that helped the immigration process? And in your opinion, which are the ones we should hold on to? I would also like to come back to the digitization of the immigration process. In your opinion, how will modernizing the system be beneficial to the immigration system? Thank you.
I've done a lot of talking. I'll let you other witnesses take the first shot.
Sure. Yeah, why don't I give it a crack? Thank you for the question. Let me start with some of the points that I made during my opening comments. So the first issue that I see is with the temporary the workers who are on the post-graduation work permits, and this was mentioned in the previous session. Because those are not able to be extended or and you can only apply for one of them per lifetime. That's been a huge issue. Hopefully that can be amended. I had one client who did a bachelor's degree. She received a post-graduation work permit. She was not able to get a job, so she did a master's degree. And then at the end of her master's degree, she had a very short term on her post-graduation work permit, but she could not apply for another one. And it was a very difficult situation. In terms of the other, I will say that the government has been very reactive, and some of the measures to allow, for example, the reunification of fiancés and other and exclusive dating relationships, we have been able to take advantage of some of those programs, and we have many clients who have appreciated those measures. And I will say that I believe that that the government is doing many things to reunify families, but we need to do more. In terms of the online systems, I'm going to defer to Mark because he's really the expert on this. But like I said, I'm just going to say one story. Mississauga is a bit of a I can't even imagine what their mailroom is like. But we've had sponsorship applications lost before, lost for 4 to 6 months. In fact, they were eventually found. But at least that would not happen if we switch to a more online system.
Thanks. I guess the one thing that I'll add is, yes, the digitization of everything, the modernization of the systems. You look at all the problems we're experiencing right now. So many of them would be resolved if it wasn't a paper-based system, or the need for visas to be imprinted in passports, or biometrics. The other witnesses in the other session talked about this. It's everything. If we can eliminate this, so many of these problems we're experiencing now will wash away.
Thank you both. I'm going to speak English. I think it's be easier for translation. What do you see how right now, and you've talked about this during the pandemic right now, we still have offices that are closed, offices are not in full operation. We don't control other countries, health regulations and how they want to work on the pandemic. So we've been faced to a lot of challenges. But other than that, what are the other challenges that you see that we have during this pandemic that affects immigration?
I can maybe step in and say this. One of the biggest issues is communication. So we can look at just about any line of business within immigration. We're dealing not only with immigration, we're dealing with the airlines, people that are refused boarding. We're dealing with the border officers and their determination what's non-essential and non-discretionary. And so people can do everything right from an immigration perspective and still get shot down. And so I think from that perspective, every effort needs to be put into making sure there's a consistent line of communication and that the airlines are getting the message. I've got clients in India who expired COPRs, got the letter from IRCC, and then were refused boarding by the airlines. So, like I said, I would never cast blame on anyone.
Sorry for interrupting. The time is up. We will now move to our next member, Madame Normandin. You have 6 minutes. Floor is yours.
Merci beaucoup.
Thank you very much. Once again to our witnesses who are giving us so much information for our report. It's very much appreciated. My first question is for Mr. Holthe. You spoke about 179B and the problems that it creates for sponsors. What about this possibility? When there is a sponsorship application, the onus is reversed and the visa is automatically given unless it is proven that there is a security problem. Do you think that would be a possible solution?
I think that's one of many, right? Built into the lifeblood of immigration is discretion. I would never, ever want that to be taken away. But over the last while, with this emphasis on expediency and trying to get things processed as quickly as possible, often decisions are made in a way that really harms people and doesn't take into consideration their real situations. In the context of family, like I said in my opening remarks, I don't think that section should apply at all in the context of someone who's subject of a spousal sponsorship. But not just that, an adoption, right? Anything that relates to family reunification, I don't think it makes sense to apply that. And the number of fraudulent situations is astronomically low, not enough to justify that measure. I think it should. I think that's a great idea to reverse the onus.
Merci beaucoup.
Thank you very much. Now I would like to ask Mr. Clark a question or a few questions. You spoke about digitizing files. Could you speak about asking for original signatures? Because original signatures and original documents are still being asked for. Should copies still be provided? And should it be at the end of the process that the original is given to the officer? And only if needed. Thank you.
I would opt more for the as needed basis. I believe that if an officer reviews an application and if there are discrepancies with the signature or there are discrepancies in as part of the application in some other point, then the officer could make an easy request to have the original document submitted. I mean, I remember when I was living in Japan they have hankos, which are stamps. And so, you can go to a special store to get a stamp, which in my, I had two Kenji characters on my stamp, and that is what they use for a signature. Signatures, in my view, are too heavily relied upon in 2020. We're already submitting copies of passports and copies of documents and copies of bank statements. Those signatures, while sure, as a lawyer it's legally binding and it's wonderful to have signatures, in my view, it needs to be a more comprehensive approach. It needs to be a more modern approach. Right now, with digital signatures, copies, scans, we try to run a digital office, and I know Mark has a much better digital office than we have. It's 2020. I think that we can do without original signatures.
Merci beaucoup. J'aimerais entendre à la fois Maître Holthe et Maître.
I'd like to hear Mr. Clark and Mr. Holthe. If the government appeals, it's probably so that they can review the agreement and have a new version of the agreement. What about the chances of success? Will we really protect refugee rights? And will we fulfill our Geneva Convention obligations? Or will we respect the Canadian Charter? Or should we just modify it?
Sorry, I'm a little unsure. It sounds like you're talking about Section 96 and Section 97, the Geneva Convention. I'm just not sure exactly what the question is.
In fact, the decision of McDonald's judge is on the agreement and the respect of the Charter, but there are also obligations pursuant to the Geneva Agreement. Should we review this agreement on safe third countries?
that's a complicated question. I mean, first of all, I completely agree with Justice McDonald's decision from the Federal Court of Canada. It's a very well-reasoned decision and you can read all of the evidence that was presented on behalf of many parties and interveners, and I strongly agree with her analysis in terms of the charter analysis. In terms of the Geneva Convention itself, Canada has been a party. We were actually one of the last signatories to the Geneva Convention. We signed up quite late compared to other countries, but in my view, the Geneva Convention is still a good document. It still contains good doctrine. It's more in the implementation of the Geneva Convention that's the issue. In particular, with some of the sections in ERPA, which call upon the government to review the Safe Third Country Agreement, and in my view, the government has not been properly reviewing Safe Third Country Agreement with the United States. But the Geneva Convention, Section 96, Section 97, in my view, are all sound documents. I regularly appear before the RPG.
Mr. Clark, sorry for interrupting. The time is up. We will have to now move on to Ms. Kwan. Ms. Kwan, you have 6 minutes. Please start.
Thank you very much, Madam Chair, and thank you to the witnesses. I'd like to first turn my attention on the issue around foreign workers to Mr. Holthe. In your opening statements, you talked about the situation with foreign workers. What we know is that the government had brought in the Guardian Angels program applying to healthcare workers only, but for whatever reason, only Lord knows why, agriculture workers, for example, who has been excluded from it, and some of them have died putting food on our table, supporting Canadians. Do you think that the Canadian government should, in fact, include all the migrant workers during this period to have status for all?
I don't like the foreign worker program, and this is where I divert. My views differ from my other role. The reality is, I see exploitation all over the place, and they never come forward, never. So not only do they have no pathway to permanent residence, but they are stuck in these jobs where they're sending money home. We've all heard the stories. There's been so many meetings here before this committee itself talking about this issue. And so I think the government needs to do it more so than ever during this pandemic, when they're in the most vulnerable state of all, putting themselves out there while we sit comfortable in our homes. And if you look, it's like the marginalized element of society is there. They're the ones on the front line. And I think we have an obligation, a moral obligation, to do something about that.
Well, thank you very much. I, like you, have a lot of difficulties with the temporary foreign workers program. The program was really meant to be for people who are truly temporary, visiting professors, for example, people in the film industry who have zero intention of staying in Canada. But somehow that has actually become a program to replace immigration processes where people can get landed status on arrival. Once upon a time, Canada actually used to have a immigration program that included high skill, medium skill, low skill. That is now gone. It's all primarily high skill now. And so you talked about creating a new program called Canada Frontline Experience Class. I guess, that would be for COVID, but beyond COVID, really, should we not bring back an immigration program that brings all the different skills to Canada, so that when workers come to Canada with the intention of staying, that they actually have landed status on arrival?
Ms. Kwan, sorry for interrupting. Can you please move your microphone close to your mouth?
No, my thing is broken. Okay, we'll see what we can do.
Yeah, please.
Okay, in response to that, I think there needs to be something done. And I think there's a mechanism in place to be able to make that happen. When they come over, if they're on a labor market impact assessment, provinces like Alberta have traditionally picked up that slack. The nominations coming from my province traditionally have encompassed those individuals. But when individuals are here in this situation, especially when they end up on, like postgrad students, for instance, who are on open work permits, the pathways in many of the provinces just don't fill in that gap. And so if an individual is on a labor market impact assessed work permit, it's often a little bit easier for them to transition through the provinces. But now there's this massive cohort of people that just have nowhere to go. And we've already heard testimony about all of the problems with the poor postgrad work permit students. So yeah, a program I think needs to be developed.
Okay, just on the postgrad situation, would you say that what we need to do for this period is to automatically extend the international postgrad students with their work permit so that they can, in fact, have the opportunity to stay in Canada and access the PR process.
I've thought a lot about that, and there's always ripple effects with everything you do. Every single cohort of people will want some help. And I think in this situation, there is no harm done by doing that, Ms. Kwan. I don't see any negative consequence of giving a short-term moratorium.
Thank you very much. I'd like to turn to Mr. Clark for a minute. In his opening statement, he touched on the refugee claimants situation and the Safe Third Country Agreement. I like to ask this question. Right now, as it stands, because of the border restrictions related to COVID, refugees, in fact, cannot get into Canada because of the border restrictions. Do you think that the government should, in fact, provide an exemption to refugees? Just because we're faced with a pandemic, it does not mean to say people are not being persecuted and don't need to get to safety. We can.
Yeah. Yes, thank you very much. Yeah, I think there needs to be something done. I mean, the judgment from the federal court, from Justice McDonald, it's very clear that the situation in the United States for asylum seekers is very dire. They are routinely detained for, I've had clients detained for up to 3 years in general population in the United States. And Canada is now an international beacon of hope. And in my view, notwithstanding this pandemic and health restrictions, I believe there should be some mechanism for us to accept some of these refugee claimants from the United States. Notwithstanding all the issues, I think a mechanism can be had to accept some refugee claimants from the United States, have them go through the system, have a fair hearing at the tribunal, and have their cases determined by an independent adjudicator.
Right. And so, but even refugees from outside of the United States, should we suspend the border restrictions so that they can, in fact, get to Canada? And once they get into Canada, we can still apply all of the health restrictions on quarantine and all of those other measures.
Yeah,
10-second answer.
Yes, I would be in favor of that. We have a strong humanitarian tradition that needs to be protected.
Thank you. The time is up. We will now move to our second round of questioning. We will start our second round with Mr. Hallen. Mr. Hallen, you have 5 minutes.
I'll defer my first, I guess, to Ms. Dancho.
Great. Thank you, Madam Chair, and thank you, MP Halan. I have a few questions for Mr. Clark. Mr. Clark, I wanted to talk a little bit about the refugee application process. I think everyone understands borders are closed. Refugees, it's been even harder than normal for them, and that's almost unimaginable, pardon me. But I wanted you to lead us through where improvements can be made in the application process, particularly the eligibility interview.
Thank you. So we have a number of refugee claimants who are here. They have submitted. So right now, the refugee claimants in Canada, they submit an email to IRCC. That email includes an acknowledgement letter, and then the file is moved over to ePost. And through ePost, they are able to upload their documents to IRCC, and they wait for medicals. Once those medicals are done, then they're able to then have an eligibility interview. Eligibility interviews are all done in person at this time. I see no reason why they're all done in person, but IRCC has not been flexible in that. They started doing some eligibility interviews in some cities. I know they're not in Winnipeg, so I can tell you about that, but in some other cities, I believe Vancouver, Calgary, and possibly Toronto, I'm guessing. So they were doing some eligibility interviews in those cities, but in all the smaller places like Winnipeg, we're not being able to do that. And that means their claims are not moving forward. That means that their claims are not being referred to the tribunal. That means that the tribunal is not able to open a file for them. And so they haven't even started with all the processing and delays at the tribunal level.
Okay, thank you very much. So really, we know that citizenship ceremonies are now virtual, which is really great news for a lot of people. So that's great. It took a number of months to get there, but we're there. So would you say that same process should then be applied to the eligibility interview?
Absolutely. I don't see any reason why we can't. Even right now, we're on Zoom. I don't see why we can't have an eligibility interview. We could have it in my office.
Right.
I have no problem with that at all.
My understanding is unless they get through that eligibility interview, they can't continue on with the process. They can't get health care, they can't work. So if they get COVID, for example, really they're out of luck. So my understanding it is critical that we get this barrier, we hurdle this barrier, so to speak, or we get over this barrier, pardon me.
Well, they can get health care.
Oh,
when
okay.
they get the acknowledgement letter, they're able to then book a medical exam with a DMP,
Okay.
and that will facilitate access to the interim federal healthcare program and a work permit. But they're not able to start their claim at the tribunal.
Okay. I did have another question regarding a case of a Chinese student that was a pro-democracy protester in Hong Kong. My understanding is they applied to come to Canada a number of times and were rejected 3 times. Can you give any information about that case?
Thank you. Yeah, this is a Hong Kong student, very educated young man. We applied in I believe it was November of 2019 for an initial study permit. It was refused after 2 weeks. In my view, it was a slam dunk case. I believe he even was educated in the United States before. I mean, he's a very strong study permit applicant. So we JR'd it to federal court without even seeing the notes. We produced the applicant's record. I spoke with the lawyer at the Department of Justice. They agreed. The note, it was actually refused. The officer said that the study program would not be a reasonable expense to our client. The University of Manitoba, it's a great school. Mark is an alum. And I don't see how a study program at the University of Manitoba is not a reasonable expense for a student from Hong Kong. But for whatever reason, it was refused. So we went at the Department of Justice. They referred it back to the visa office, and it was refused again. And so right now, the client is extremely frustrated. They don't understand, and we're trying to fix this.
Do you find it concerning that someone who is a pro-democracy protester in Hong Kong is really getting roadblocked getting to Canada? I mean, the announcement last week, you would think that this would be a no-brainer.
I completely agree. In my view, it doesn't make sense. The government is saying one thing, but the officers on the ground are doing other things.
Thank you, Mr. Clark, and thank you to all the witnesses. Appreciate your time.
Thank you, Ms. Dencho, and thank you to the witnesses. We will now move on to Mr. Reagan. Mr. Reagan, you have 5 minutes. Floor is yours.
Thank you very much, Madam Chair. Mr. Clark, you may have to send a bill to Mr. Holthe for all the good things you're saying about him and his firm. I'm sure they're appreciated. I want to ask both of you, as you're aware, as a result of the pandemic, because I understand that the IRB suspended refugee hearings, but it's since resumed them virtually. And during the suspensions, I gather that IRB members used their time to work on previously received cases and to try to work on system efficiencies so they could improve or optimize case intake and processing. How do you see this affecting the refugee claims process, and what issues have you noticed that can be improved upon, and how would you do that? So Mr. Clark and then Mr. Holthe, please.
Thank you very much. So that's entirely correct. The IRB and in particular the RPD did suspend its hearings, I believe in March, and then we started the remote hearing pilot project, I believe in July, and we had hearings approximately weekly through August, September, and October through that and then we resumed in-person hearings in I think October. And we might be going back to and now we have actually remote hearings scheduled again coming up. So in my view, the remote hearing pilot project was a very positive experience. The RPD members were extremely professional, and I believe the refugee claimants had a good opportunity to give their testimony and to have their evidence considered.
Yeah, and I don't have too much more to add other than what Alistair has indicated.
Okay, thank you. My next question is for Mr. Holthe, and I hope there'll be time for Ms. Mahmood also. The government's indicated that family and spousal reunification is a priority for it, and it recently made an announcement on spousal sponsorship, indicating that the level of IRCC staff was being increased by 66%. That is to say, those who are working on this issue on spousal sponsorship, to make sure that they were continuing to address the backlogs. And the government says this will increase. This increase would lead to 49,000 decisions by the end of the year, and it's looking to pilot remote interviews as well. And also, I'm aware that spousal applications are all being digitized. First of all, do you see these developments as helpful to reduce the backlogs? Secondly, will they aid in modernizing the system by decreasing the extent of inefficiencies? And if not, what else is the right answer here?
Yeah, absolutely. Every step they've been taking is positive, and I applaud them for it, without any doubt. These innovations that are being created because they've been forced, the government's been forced to make changes, no different than with the Syrian refugees and the inefficiencies that they were able to create, which are wonderful. One of the problems, though, I will bring up is that in order to get those queues down, many spousal applications are being returned for very frivolous reasons, very small little things like maybe no wet signature. And then people who've been waited 6-7 months are now back at the queue, the front of the queue again. And so this is just, I think there needs to be a little bit more compassion versus the one-touch policy. But yeah, I really, really like the positive developments that have occurred and how IRCC has reacted.
Ms. Mahmood?
Yes. Yes, sir.
Did you hear my question about the backlogs and the efforts to try to reduce those? What are your thoughts on this?
Actually, I do agree with what the lawyers just explained. I think the developments are improving the system for reunifications of families, but also just I would like to mention that up till now, there's a different treating between the people of countries who need to have a TRV and people who need just to come here with ATA because it's so different. People at least with ATA can come just to stay with their spouses, with their families, and after that they can actually apply for in Canada spousal sponsorship. But the situation is completely different for people who need to get a TRV. As I just mentioned for my client, I cannot believe that somebody is just waiting for 10 years to be joining a husband or a wife.
Would you
Thank
say?
you. Sorry for interrupting, Mr. Reagan. The time is up. We will have to now move on to Madame Normandin. Madame Normandin, you have 2.5 minutes.
Merci.
Thank you very much. I would like to come back to the Safe Third Country Agreement. I would like to know what is your opinion with regard to the two options. Modify the Safe Third Country Agreement in order for it to meet the Justice McDonald's decision, or just to abolish the agreement. What do you think about these two options?
That sounds like a question for me. In my view, I would suspend the agreement. I believe it needs to be suspended, and I believe it needs to be renegotiated. As long as the United States clearly violates accepted principles of international law, it is in violation of the agreement as it was originally negotiated, and therefore it should be suspended until the United States can show again that it respects international human rights principles, and then Canada will be able to be comfortable with being a part of such an agreement.
And on the issue of open work permits and closed work permits, when the permit is closed, the worker is sort of stuck with one employer, basically. So what do you think about permit per sector or per type of employment? So sometimes a welder has enough or too many welders, but the company next door could use a welder. What do you think?
I can step in on this one. I think the open work permit is a great leveler. amongst employers. And we have some amazing employers who care for their workers, but there are a lot that don't. And there's nothing more powerful to an employer when they see their employees leave. Are we still okay? Yeah. So when I see, so when we see employers losing employees to their competitors, that's a little indication of how well they're treating them. And so I love open work permits. I think, like I said, I think it's a great leveler, and it helps to remove the ability of an employer to kind of really hold.
Sorry for interrupting. Time is up.
Okay.
We will have to now move on to Ms. Kwan. Ms. Kwan, you have 2.5 minutes. Floor is yours.
Thank you. Yeah, I'd like to just touch on some of the issues with how IRCC deals with applications that come in that's missing something. And then they send the entire application back. And then people have to start all over again is my worst pet peeve, I have to say. So to that end, should the government really fix this to say that those that have these applications returned, when the applicants receive the return submission, should they be allowed to then have an expedited process afforded to them? So Mr. Holthe and Mr. Clark, very quickly, and then I have a different question.
Yeah, that's a tough one. So I think there needs to be some compassion built into it. That if there's something that's just a little thing that's missing, then I agree that they should have the opportunity to have their application put back into the queue where it should have been, but for the little error. And remember, years gone by, they would send deficiency letters. You're missing this, but it was taking too long. We weren't able to meet these high processing standards. So those are my thoughts.
Quick answer from Mr. Clark on this.
Yeah, I don't think those applications should be returned. I think there needs to be better communication, more collaboration. To a certain extent with those applications, we're on the same side. And if there are minor issues, minor mistakes that can be easily dealt with, it'd be good to have more communication with the officer. We can fix it. We can send in the missing document or the document with the missing signature, and it should be processed according to the queue.
Yeah, that's the ideal universe, but it doesn't happen. I actually have a case right now where someone sent in their PR application with a letter of completion from the university because they couldn't get their degree because it was interrupted because of COVID. Their entire application was rejected. And then they tried to appeal it and it was rejected. And so now they've come to my office and I'm writing a letter to the minister trying to see if we can get this fixed. And it's just so wrong, right? And so if we're talking about modernizing, how about just some very basic level common sense and decency and compassion in the approach? So so I have to say this, and so from what it sounds to me, like that is part of a key recommendation as part of the modernization.
Absolutely, and I believe there are some good online tech solutions for this type of problem, and I think if we use the tools that are already out there, this can be fixed.
On the online piece, we also ran into cases where people have some slight
Sorry for interrupting, Ms. Kwan. Your time is up. Based on the time left, we will end our second round of questioning with 2 minutes for Ms. Dancho and then 2 minutes for Mr. Dhaliwal. So, Ms. Dancho, you have 2 minutes.
Chair, I'll see my time to MP Helen, since I took all the time last time.
Thank you, MP Dancho. I'd just like to get the witnesses' opinion on, this is something that we see very regularly now, that most of these temporary foreign workers, we've seen how essential they are, especially during the pandemic. Many truckers had to go through hardships. They were transporting life-saving supplies all across the country, and they were having to go without having washrooms open for them, couldn't get through the drive-throughs because they were in big trucks. They had to face many hardships. These are people that, and alongside with most frontline workers are a lot of temporary foreign workers. When it comes to dignity, a job is a job, and they should be held to that high standard. Sometimes we talk about low scale or high. I don't think that we should really classify them as that because we've seen how essential they are. Is there a pathway we can find for these essential workers that would help them get their PR? I'd love your guys' opinions on that.
I'll step in here. For a long time, Alberta had a long-haul truck driver stream that was designed to facilitate individuals in that exact situation. Now the world has been turned up on its head. You see what's happening in Alberta. Our do not process list is basically excludes pretty much everyone. And it's an exception if someone aren't excluded. So yeah, we need to take care of them. There has to be a pathway forward, and the way IRCC has things set up right now, it's not designed to accommodate for anyone that's not C or D.
I will add that the EMPMP program here in Manitoba does have some good programs for long haul truck drivers. We have a very good community of truck drivers, and they're on a path to PR, and we help many of them. And like you said, I mean, it's a very tough job. I've had conversations with clients, and they're basically living off of snacks in their cab because
sorry for interrupting, Mr. Clark. Time is up. We will now end our round of questioning with Mr. Dhaliwal. Mr. Dhaliwal, you have 2 minutes.
Question is to Mr. Holt. Earlier we spoke about the strategy of our government to involve creative methods to reach out our newly presented immigration levels target of 1.2 million over the next 3 years. And our government will have to explore transitioning temporary work permit holder residents already in Canada to permanent residency. You mentioned the immigration system focuses only on high-skilled workers. Do you believe putting a higher emphasis on lower and medium-skilled workers as part of increasing economic immigration is a good place to begin, or pathway for permanent residency?
Yes, yeah, I agree. I love the express entry system. I think it's fantastic, and I think it has the ability to adapt quickly and to pivot when needed. And I think that we really need to create a pathway for those low-skill individuals. Personally, right now, with the emphasis needing to be on Canada, I think we need to do more CEC draws. And we've had a string of open ones, and the comprehensive ranking system scores are off the charts. And I think we need to do more CECs and then look at opening up a program to accommodate these low-skill individuals.
Can you give me, for example, earlier Ms. Kwan was mentioning the agriculture workers. Today, if we look at this, every year in British Columbia and particularly in the Fraser Valley, we need hundreds and thousands of those workers, and we can meet that demand. We bring people from Mexico on a temporary basis, and it didn't work during COVID. And how do you see these people getting into the system if we still have this express entry, and those points are only assigned to the high skilled? But at the same time, we want to make sure that we are able to achieve the economic prosperity that we are looking for.
Sorry, Mr. Dhaliwal, your time is up. Sorry for the interruption. With this, we come to an end to our round of questioning. I want to take this opportunity to thank all the 3 witnesses in the second panel for your important testimony and important discussion as we continue our study on the impact of immigration. Before we adjourn, just for the members, the clerk would like to talk for a second in regards to the witnesses to be scheduled for Monday's meeting. So I will pass it on to the clerk to please let the members know in regards to the scheduling of the witnesses.
Thank you so much, Madam Chair. Just to let members know that the current witness list, the current witness list might not have enough members to fill the panel for November 30th. I'll be emailing the members the updated witness list and the calendar for November and December tomorrow morning. And if members could follow up with me at your earliest convenience, that would be greatly appreciated. Thank you so much, Madam Chair.
Okay, thank you, clerk. And if the members can let the clerk know, that would be really great. With this, we will adjourn the meeting. Thanks again to the witnesses for appearing today. Good night, and thank you to all the members. Have a good day. Stay safe. Thank you.
Thank you. Bye.